Case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the people are represented by Mr. Brockler, Ms. Teach McGuire, Ms. Pearson, Mr. Orman, and Mr. Edson. We are outside the presence of the jury. Juror number 661 indicated that she wishes to speak with me, so we're going to bring her in and see what's on her mind. Could you please bring her in? The record should reflect that juror number 661 is now present in the courtroom. Good morning.
Good morning.
How are you?
I'm doing okay.
All right. My understanding is that you wanted to speak to me. What's on your mind?
Well, I just wanted to inform the court that I inadvertently ran into a former juror this morning when I was exiting the ladies' room on the first floor. And I said, excuse me, as I almost bumped into her, but I just wanted everybody to be aware that was not an on-purpose collision there. So I just said, excuse me, moved on. We both did a double take, but nothing else was said.
You weren't hiding in the bathroom waiting for her to show up.
I was. You found me out.
I understand, and I appreciate you letting me know.
Okay.
I've had my staff speak to her, and she understands that there's an order that prevents you folks from having any contact with her.
Okay.
She also understands that she is to attempt to have no contact with you. It sounds like this was inadvertent.
It was. She wasn't trying. It was literally a near collision. So.
Okay. All right.
That was it. I just wanted you to be aware.
I appreciate you letting me know. Thank you.
Sure. Thank you
very much. The record should reflect that juror number 661 has now exited the courtroom. Are there any other questions that either side wishes to have me ask her, or any requests that either side has for me right now?
No, for both of those, Your Honor.
Okay. Mr. King?
No, not at this time.
All right. And for the record, one of the jurors who has been excused from the trial, juror 901, is in the courtroom. And this is a proceeding that's open to the public, so she's welcome to be in the courtroom. I did have my staff remind her that the jurors can have no contact with her, and she's to have no contact with the jurors. I've also had my staff remind her that there's an order that prevents the media from speaking with her, and I had my staff indicate to her that I have entered an order that prevents the lawyers or any of their staff members from speaking with her. So she understands all that, and I'm confident that she will follow all of those, all of my orders. So, two things before we bring the jury in. The first one is, yesterday during a bench conference with Mr. Orman and Ms. Higgs, I admitted People's Exhibits P-TR-1249 and 1250 under the public records exception to the hearsay rule, which is Rule 8038. In the process, I sustained the defense's objection to the records coming in as business records under the business records exception, Rule 8036. And I did that pursuant to People versus Marciano, and after finding that the people had not established the fifth requirement that's listed in that case. That requirement being that the information was transmitted by a reliable person with knowledge of the events reported. I went back at the end of the session yesterday and went back through my notes, and based on my review of my notes of the testimony of Dr. Finger and also the testimony of Ms., I believe her name is Amy. Let me just make sure. Yes, Carrie Dawn Amy. I am going to change that part of my ruling, and so I am going to admit the records both under the public records exception, but also under the business records exception. And specifically, what my notes reflect is that there was testimony from Ms. Amy establishing that the individuals who sent the emails in those two exhibits that I mentioned are employees of the University of Colorado, that they are professors at the University of Colorado, that the information contained in the two emails constitute the activities of employees at the University of Colorado, that the University of Colorado is a public agency that's part of the state of Colorado, that both of these records were made in the ordinary course of business by professors who were acting in the routine and ordinary course of business at the University of Colorado, and that these professors had first-hand knowledge of the information sent in the emails. So based on that evidence and based on other evidence that has been presented in this case, including the testimony of Dr. Finger, the testimony of other professors from the University of Colorado whose names were included in at least one of the emails, and in light of also of Exhibit 1220, P-TR-1227, and all the other evidence introduced in this case, I am satisfied that the people presented sufficient foundation to establish that the information in each of these exhibits was transmitted by a reliable person with knowledge of the events reported therein. So I'm admitting them under both 8036 and 8038. The second thing I had was with respect to the jail cell video. And Mr. Orman, can you remind me what exhibit number that is?
I'm sorry, Your Honor, I was speaking about this in my protocol about court exhibit.
The jail cell video, what number is that?
Let me check on that.
I believe it's Exhibit 1089.
1089? I have a question about that. I don't remember Dr. Reed or Dr. Metzner referencing that video or talking about that video or indicating that they had reviewed it. Is that because the video surfaced in January of this year, or was there a different reason for that?
No, I think Mr. Brockler, since he had those witnesses, maybe the better person to answer that.
Oh, okay. Mr. Brockler?
Or recall that, that the video didn't surface until well after they had generated their reports and their opinions on this particular case.
All right. I thought more about this exhibit for obvious reasons, and after thinking about it further, I continue to believe that it is admissible. I think that the defense has, in a way, opened the door, if you will, to this evidence by relying on the November 2012 video. The video from November of 2012 is a jail cell video that shows the defendant appearing to either fall from his bed backwards onto the floor or throwing himself backwards. And then there is some subsequent video during the time that he was hospitalized following that incident at Denver Health Medical Center, where he is apparently running and ramming his head into a wall. The defense showed these videos in opening statements. and also sent the videos to Dr. Reed and I believe Dr. Metzner, and those experts reviewed those videos, relied on those videos. The defense has argued that this is evidence that the defendant was psychotic in November of 2012, and that the evidence that he was psychotic in November of 2012 supports the argument that he was also psychotic back in July of 2012, on July 20 of 2012. And so given that, and I think the experts talked about that as well, by the way. I think both Dr. Metzner and Dr. Reed spoke about that incident in November and spoke about how that incident is supportive of someone being in a psychotic state or suffering from psychosis. I think given that, the people's video, which is Exhibit P-TR-1089, I believe is what Mr. Bruckler just said, which took place in September of 2012, so a couple of months earlier. I think it's going to be up to the jury to decide what weight to give to it and what inferences to draw from it, but certainly I think that reasonable inferences can be drawn from that video that these are not the actions of someone who is psychotic, that these are not the actions of someone who is detached, logically process information, to rationalize things, and to intend to try to take some of the actions that are depicted in the video, including what appears to be trying to get out of the shackles, out of his shackles, and then checking the door on multiple occasions, apparently looking to see if any of the sheriff deputies were coming or were watching him. I think a reasonable inference can be drawn that this is evidence that shows that the defendant was had the mental capacity and cognitive abilities to distinguish right from wrong and to form the culpable mental state elements that are required by the crimes charged in this case. Whether the jury is going to draw those inferences or not, I don't know, but it certainly has a lot of probative value given the videos from November and given the issues that are before the jury in this trial. The question then is, what's the potential for undue prejudice? And there is potential for undue prejudice. For that reason, I'm going to give the jury a limiting instruction, the limiting instruction that I have given at other points in this trial, which is that they are to consider the video only for purposes of the issues raised by the not guilty by reason of insanity plea. If the defense wants me to give a more extensive instruction or a different instruction, I'm happy to give it. For example, I'm happy to tell the jury that the defendant was not charged with any misconduct as a result of that incident, and that he's not charged with any crime in this case related to that incident, and they cannot consider it for that purpose. I suspect that these points are going to be made on cross-examination, but if the defense wants an instruction along those lines or any other type of instruction, I will entertain it. So you can let me know. But I think that the instruction that I plan to give will tell the jury the specific purpose for which it is being admitted, and I have confidence that this jury will follow that instruction. So I wanted to make that additional record. Lastly, I thought about the objections to Ms. Mosher's proposed testimony or anticipated testimony, and so let me go through those quickly. First of all, I appreciate Ms. Brady bringing this up ahead of time. It's helpful, and it avoids having interruptions during the testimony. The first 3 points that she made, I look at as part of one objection because I look at them together, and that is that Ms. Mosher apparently intends to testify that she dropped off her daughter at a babysitter's residence so that she could have an ultrasound or attend an ultrasound appointment, that she then was excited about hearing news that she was going to have a baby and wanted to celebrate, and that for that reason she took her daughter and I think Kaylin Bailey and perhaps someone else to the movie, and that she thought the Batman movie was going to be a cartoon movie, but then thought, oh my God, I hope Veronica won't be scared, end quote. And the objection is under Rules 401 and 403. So let me address 401 first. The question under Rule 401 is whether this is relevant. And I think it is. It is relevant because I think Ms. Mosher is entitled to explain why she brought a 6-year-old child to a midnight movie on the day in question. We heard at least a couple of prospective jurors during jury selection question why a mother would bring her young daughter to a midnight movie, especially a midnight premiere of Batman. And so I think she's entitled to explain that. I don't know whether any of those prospective jurors ended up making it on the jury, but I think it's a natural question that people may have, and I think it's a question that some of these jurors may have. And so I think that she's entitled to explain why she brought her young daughter to this movie. So it is relevant. The question then under 403 is whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice. And I believe that's the concern for the defense when the defense cites Rule 403. And if not, the defense can correct me. But if the jury was not going to hear that Ms. Mosher was pregnant and that she lost her pregnancy as part of the shooting and the injuries that she sustained during the shooting, I likely would keep this out because I would say, okay, the probative value is there is some probative value, but the potential for undue prejudice substantially outweighs that probative value. But in this case, I've already ruled that the jury can hear that Ms. Mosher lost her pregnancy as a result of the injuries that she sustained in the shooting. So having the jury hear that she had an appointment for an ultrasound and that she found out that day that she was going to have a baby and wanted to celebrate, I don't think that is so prejudicial that it substantially outweighs substantially outweighs the probative value of the evidence. It's not particularly prejudicial, and I find that it is not unduly or unfairly prejudicial. So I'm going to allow that anticipated testimony. The next point had to do with Veronica Mosher wanting to sit on her mom's lap and Ashley Mosher telling her no because she was pregnant and it was uncomfortable, and Ashley Mosher then wanting to say or testify that the last thing she said to her daughter is, "You're a big girl and you can sit in your own seat." And there's an objection as under Rule 401, Rule 403, and under Rule 802. I'm going to sustain the objection with respect to this issue. What's relevant is not why Veronica was sitting in her own seat or what seat she was seated in. What's relevant is the fact that she was seated in that seat by herself. That's what's relevant. And I'm not concerned that if I don't allow an explanation that the jury is somehow going to be wondering why or going to be distracted by that or going to be speculating about that. Veronica was 6 years old at the time, and I don't think there's anything unusual with a 6-year-old sitting in her own seat at a movie theater. So under Rule 401, I find that this has no probative value, and so it is inadmissible. And because of that, it is also inadmissible under Rule 403. Actually, I don't have to get to Rule 403, so I'm keeping it out under Rule 401. But to the extent, yeah, go ahead.
I apologize for interrupting, but as we go through these, if I ask for some clarification, do you want me to wait for the end and come back, or do it as we go?
Why don't you ask me as we go through it?
Just so that I'm clear on this one, and I understand the court's ruling, is
Yes.
it as to the statement that Ms. Mosher Sullivan made to her, or the act of her daughter initially sitting on her lap, but then because it was painful being put in that seat, or both of those things?
She can testify that she initially sat on her lap and that then later moved to her own seat and that she was uncomfortable, she felt uncomfortable. You'll just have to avoid any hearsay. So she can't testify about what she said or why she said it or anything like that, nor can she testify about what the last thing is that she said to her daughter. And to the extent that there's any probative value to this, the probative value is substantially outweighed by the danger of unfair prejudice. So the next one is when Ashley Mosier was shot, she fell on top of Veronica, and she was asking Kaylin if Veronica was breathing. And Kaylin said, "I don't know." And there is an objection here under Rules 401, 403, and 802. And Mr. Brockler acknowledged yesterday that he's not wedded to Kaylin's statement, but it's Ashley Mosher's statement that he's most interested in. I think what's relevant here is that when Ashley Mosher was shot and fell on top of Veronica, that she couldn't tell whether Veronica was breathing. I think that's fair, and she can testify to that. I don't think she needs to testify about what she said or what Kaylin Bailey said. I think she can simply say, I was trying to figure out if Veronica was breathing and I couldn't tell. So the hearsay objection as to both of those statements is sustained. I'm not convinced that the present sense impression with respect to Ashley Mosher's statement applies. And I'm not convinced that the excited utterance exception with respect to Kaylin Bailey applies. And frankly, even if they apply, they still have to be relevant. And even if they're relevant, I find that under Rule 403, the probative value, which is marginal, would be substantially outweighed by the danger for unfair prejudice. So I will keep the statements out, but she can talk about what she was thinking, what was going through her mind right after she was shot and she fell on top of her daughter. I think that's fair, and I think that's appropriate. Next is Kaylin Bailey asking Ashley Mosher if Ashley Mosher could move off of Veronica, and Ashley saying that she couldn't. There's an objection under Rules 401, 403, and 802. Let me address the Rule 802 objection first. I don't know, again, why the statement is relevant. It seems to me that what's relevant here is that to the extent that the statement is relevant, it's only relevant because of the effect on the listener, which in this case would be Ashley Mosher. So if you're asking it in terms of, why she tried to move off of Veronica, and then she realized at that point that she couldn't move off of her, then that's fine, because that's not hearsay, and I think that's part of what happened, and I think it's relevant, and that's admissible. So if it's the kind of thing where the reason why she tried to move off of Veronica is because Kaylin said, "Can you move off of Veronica?" then that question by Kaylin Bailey is not being admitted for the truth of the matter asserted. It's being admitted to show the effect on the listener, the effect on Ashley Mosher. So it's not hearsay, so the Rule 802 objection is overruled. And it is relevant because it's part of what took place, so the Rule 401 objection is overruled. And I find that the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. This is part of what took place immediately after the shooting, apparently, and I think the people are entitled to present that. So, again, if that's the way the people are intending to present it, Mr. Brockler, then I'm finding that it's not hearsay. But it has to be strictly to that one question and tied to why she tried to move off of Veronica. Next is, when Ashley was being carried out of the theater, her pants fell down. Mr. Brockler argued that this is part of what happened. And to the extent that that's part of what happened, I agree that it has some probative value. So it is admissible under Rule 401. So the Rule 401 objection is overruled. The question is under Rule 403, is there any risk for unfair prejudice? Given what else this jury is going to hear from Ashley Mosher, I don't see how this is prejudicial. I don't see how this is prejudicial, much less unduly prejudicial. And so under Rule 403, I find that the risk for unfair prejudice does not substantially outweigh the probative value of the evidence. But I want to make sure that people are careful not to belabor this. In other words, I don't want them to make this a point of emphasis where she's talking about how embarrassed she felt and how and go on from there. And it's the kind of thing where she was being carried out, this happened, and she's talking about it, and then you move on. Next is when Ashley got to the hospital, she heard one of the medical personnel talking about a CAT scan, doing a CAT scan on her because she was pregnant. And Mr. Brockler agreed that this is hearsay and that it should be excluded. And even if he hadn't agreed, I would have sustained this objection. This clearly is hearsay, and so it is inadmissible. But I appreciate the people being candid. Next is at the hospital, Ashley Mosher asked her mother about Veronica's status, and her mother apparently told her that they were taking care of her. That's hearsay. I can't remember now if the people agreed that that's hearsay, but it is hearsay and it's inadmissible, so that's not coming in.
Forgive me, Your Honor, one of the things I failed to do was add in the fact yesterday that at the time that the mother, I believe, tells Ms. Mosher Sullivan that, it's not true. Veronica has already died, but they are sort of misleading, I think, Ashley to, I guess, keep her mind off of that and to focus on whatever treatment she has. So to that extent, it wouldn't be offered for the truth of the matter asserted. And I failed to tell the court that yesterday.
All right, I appreciate that. It's not particularly relevant, though. I don't know what the probative value is. What's probative is that at some point she found out that Veronica did not survive. That's what's relevant. I don't think, I think that conversation with her mother and her mother trying to keep this information away from Ashley Mosher, while understandable, doesn't have any particular probative value here. So I will keep that out under Rule 401 and Rule 403. So to the extent that it has any probative value, I find that the risk for unfair prejudice is large enough that it gives me concern, and I will not admit it under Rule 403. But I will allow the people to elicit testimony that at some point she found out that Veronica did not survive. And in fact, if you want to ask, at some point Sunday, I think it was, did you find out that Veronica did not survive? I think that's an appropriate question. And it should be phrased in that fashion. Did she at some point find out that Veronica did not survive? And to the extent that there is a 401 objection to that, the objection is overruled. And same thing with a 403 objection. First of all, the jury really knows about this. So I don't know what prejudice there is. They know that Veronica Mosher Sullivan did not survive. And I think it's probative to allow Ashley Mosher, I think it's appropriate, I should say, to allow Ashley Mosher to say when she found out that her daughter didn't survive. But it's a one-question proposition. In terms of the hearsay objection, I suppose technically it's hearsay, but there's no other way that people can get that information that at some point she became aware that her daughter is no longer alive. I think she has to be able to testify about that without going into a particular statement that was made to her. So this is based on her awareness that her daughter is not alive. And I think she can testify about that. Next is, Ashley was told at the hospital that she lost her unborn baby. Same type of thing. I think it's technically, I suppose it's hearsay, but the question should be phrased in terms of, at some point, did you find out that you had lost your unborn baby or that you lost your pregnancy? I think that's appropriate. This is her body. Of course, at some point, she became aware that her unborn baby was no longer alive, just as at some point she realized that her daughter Veronica was no longer alive. Whether anyone had told her that or not, she still at some point would have found that out. She still would have realized that. She would have become aware of it. So I'm going to overrule the hearsay objection on that. It has some probative value because this is part of the injuries that she suffered in this case, and the probative value is not substantially outweighed by the risk of unfair prejudice for all the reasons I stated in the record that I made a month ago, or maybe longer, when I admitted the loss of her pregnancy as evidence of her injuries in this case. So it is admissible under Rule 403. Next is that they had to remove the upper left lobe of one of her lungs, and that she now as a result, has to use oxygen at night. And there's a 401 and 403 objection. The objections under Rule 401 and 403 are overruled. This is consistent with the order I issued earlier in this case, setting the parameters for what's admissible in terms of the injuries suffered by the victims in this case. This is clearly part of the injuries that Ms. Mosher suffered, and I think it's appropriate evidence. And the left lobe of one of her lungs is strictly related to an injury, and the fact that she now has to use oxygen at night is part of the permanency or the consequence of the injury. And so that's within the parameters that I have set in this case, and I will allow that. Next is that she still has bullet fragments in her body and spinal cord. The Rule 401 and Rule 403 objections are overruled for the same reasons. These are part of the injuries that she sustained in this case, and part of the nature, extent, and the permanency of the injuries. Next is she had to stay at Craig Hospital from August of 2012 until December of 2013. Again, this comes within the parameters that I have set in this case, but I will not allow any activity in terms of what was taking place at Craig Hospital. It's a one-question proposition. How long were you hospitalized? And then she can answer between August 2012 through December of 2013. That, again, is related to the nature and extent and character of the injuries. And so, and it falls within the parameters that I have set. So the Rule 401 and Rule 403 objections are overruled because I find that it has probative value, and that the probative value of the evidence is not substantially outweighed by the danger for unfair prejudice. In terms of the string of things that she had to learn to do again, that Ms. Mosher had to learn to do again, I'm not allowing any of those, and I'm not sure that the people were interested in any of them, with one exception, and that is nerve pain. Neuropathy is a part of the injuries that she suffered in this case. That's part of the consequences of the injuries suffered. So to the extent that the people want to ask about that, that's appropriate, and to the extent that there's a Rule 401 and Rule 403 objection, the objection is overruled. It has probative value, and the probative value is not substantially outweighed by the danger of unfair prejudice. And this also comes within the parameters that I said in my previous order in terms of what's admissible as it relates to the injuries. I had a question. Mr. Brockler, I think, wanted to introduce evidence about how Ms. Mosher had to learn again how to use a spoon. And I'm not sure I know enough about the injuries to be able to understand the probative value of that. So I need more information. So I specifically need to know, was this a cognitive injury, and that's what the people want to get into, or is it an upper body, some type of upper body motor skills type of injury, and that's why the people want to get into this, or is it something else?
Your Honor, immediately after this, she was classified as a quadriplegic, and still remains technically a quadriplegic for diagnosis purposes, it sounds like. But in the intervening time since this shooting, because of the location of her paralysis at C7, she has been able to slowly regain limited use of parts of her upper extremities, and this spoon issue is part of that.
Well, I think you can introduce evidence along the lines of what you just said without getting into specifics like learning how to grab a spoon or learning how to do specific things. I think saying that her upper body was affected by the injuries she sustained is appropriate, and including her motor skills, and the fact that she was initially diagnosed as quadriplegic and perhaps technically may still be diagnosed as quadriplegic, but that she has learned or has been able to regain some movement in her upper body. I think that's fair, and I think that's appropriate. It's admissible under Rule 401 because it has probative value. It goes to her injuries. And it's admissible under Rule 403 because the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. These are the injuries that apparently she suffered, and it comes within the parameters that I have set in the order that I issued earlier in this case. So let me see if I can find that order. just so that the record is completely clear. It's Order C-200, order supplementing the court's ruling related to evidence of the nature, character, extent, and severity of the surviving victim's injuries. That's an order that I issued after the trial started on May 5th, 2015. So the last thing on my list is, let me back up just a moment. One of the things listed in the string was physical therapy 3 to 4 times, I think a week or something like that. I'm not allowing that either. I think, saying how long she was hospitalized and generally explaining the extent and character and nature of the injuries is what's appropriate. And so I don't think it's appropriate to go into the specifics in terms of how she had to learn how to use a spoon again, she had to learn to sit because of balancing issues, or to transfer from the wheelchair to the bed, or how to make a sandwich, or that she attended physical therapy after being released from the hospital 3 to 4 times a week at Craig, or how she has fallen, or how she can't use the restroom or get dressed, or how she's had subsequent infections, or anything related to Veronica's funeral. I think those are all excluded. I don't think those are all excluded. But like I said, the nerve pain, I think is appropriate. Lastly, I have the photograph of Veronica Mosher, and the people are asking to be able to show a photograph of Veronica Mosher while her mother is testifying. And there's an objection under Rules 401 and Rule 403. I went back and looked at my notes, and I show that Veronica Mosher's photograph has been shown only one time in this trial since the people started putting on their case. And it was, I think, when Kaylin Bailey testified. That's when it was admitted, and then it was briefly shown to the jury. I'm going to allow the people to show it, but literally for 3 seconds. So, and if you want to ask, is this your daughter? And then show the picture, and then take it down. And then that's going to be it. And then if you want to ask other questions after that, you can, but you can show it briefly. I think that addresses the concerns. I understand that the defense wants me to exclude it. I'm not excluding it because I think it's appropriate for the people to ask Ms. Mosher if this, to identify her daughter, and if this is a picture of her daughter. I think that's appropriate, but because I understand the concerns from the defense in terms of the possibility for unfair prejudice, I'm requiring that it be brief. Okay? So under Rule 401, it is admissible because it has probative value. Under Rule 403, it is not inadmissible because the probative value is not substantially outweighed by the danger of unfair prejudice, given that I'm limiting the people to just a couple of seconds, just a few seconds of showing the photograph. I think that takes care of all the objections. Did I miss anything, Mr. Brockler or Ms. Brady?
I'll defer to Ms. Brady on that, Your Honor.
All right. Mr. Brockler, do you have any requests for clarification for me, or do you understand all my rulings?
I understand the court's rulings, and in my preparation with Ms. Mosher Sullivan, I'll make sure I review these things with her as well.
Okay, I appreciate that. That's why I'm having this discussion now with you, to give you time to go over them with her before tomorrow. Ms. Brady? Great, thank you. Okay. All right, can we bring the jury in at this time?
A couple other matters, if I could, Your Honor.
Yes?
May I approach? For 2 items that I intend to get in through witnesses this morning, most likely after the morning break, given where we're at. I failed to have them here before we wrapped up yesterday, and I apologize for that. I have spoken with defense about them. One is an application for admission that the defendant submitted to CU and all of the records relevant to that. And then one is his application for in-state tuition and some other documents. My hope is, because one of the witnesses we're going to call this morning, Judge, is going, not witnesses, I think we're going to publish those CU emails, and I think that's going to take some time for the jury to review, that my failing to get this to you last night won't keep the court from being able to review it before we hopefully call this person. May I approach with those?
Yes.
One is People's 1254, the other is People's 1255. One small note about People's 1255, the court will note that there are individual pages sort of highlighting what each of the documents behind them are. That is merely for ease of having a conversation on the record about which documents, if any, the court might ultimately admit or not admit. The actual exhibit will not have those pages in it, and I've spoken with Ms. Higgs about that as well.
Okay, thank you. Thank you. And Ms. Higgs, do you have an objection to these two exhibits?
Your Honor, I do. With regard to People's 1254, I would first point out that I spoke with Mr. Brockler because Mr. Holmes' Social Security number is on a number of those pages. And he actually suggested to me and agreed that that would be redacted, so that will not be a concern of mine. And we also agreed that perhaps this document should be another document not released to the media. It does contain like tax return information and other things of that nature.
All right, that request is granted.
I will make a 401, 402, 403, and 802 objection on that document. With regard to Exhibit 1255, again, I think we're in agreement on redacting where Mr. Holmes' Social Security number is located on these documents. And in particular, with regard to the letters of recommendation that were submitted by, it would be CU page 000019, 17, 18, 15, and 16. Um, 41 and 42. Those all are documents that are recommendation letters provided to the university on behalf of Mr. Holmes from professors at UC Riverside. I believe in particular those statements are hearsay. I think they're being offered for the truth of the matter by the prosecution, and that there is no exception to the hearsay rule with regard to those specific documents. I also object under 401, 402, 403, and 802 with regard to the entirety of this document. I'll let the court review that and Mr. Brockler respond. I'd also note that all of my objections are also under due process, right to a fair trial, and right to a fair and reliable sentencing hearing under both the United States and Colorado Constitutions.
All right, thank you. Mr. Brockler, do you want to respond to the objections?
Your Honor, I believe as regards 1254, and I agreed, in fact, I think I suggested that we would go ahead and redact out the Social Security number for anything that ultimately got admitted into the record. The court will note that the copy it has, those Social Security numbers remain in place. Our paralegal's working on the redaction right now. And I know the court's already ruled, but I agree it shouldn't go out to the public as well. As far as 401, it is absolutely relevant because of the time in which it takes place, and the court has made lengthy and numerous records about this exact same period of time. And what this document shows is that the defendant had the presence of mind, intent, and ability to file for in-state tuition to reduce his tuition payments on April 9th of 2012. I think 802 being part of the objection, I think this is going to come in as not only a business record, but as a statement of the defendant. It's an application that he submitted along with his digitally signed tax returns, electronically filed tax returns, and it has his notarized signature on it. And I think the combination of those two things will overcome the 802 objection. As for the application for admission to the grad school, I'm sorry.
So you're not offering, you're saying that you're not offering the application for the truth of the matter asserted, and so it's not hearsay. You're not offering the application or the tax return for the truth of the matter asserted.
Can I have 1 second, Your Honor?
Yes.
Your Honor, it's not hearsay because it's a statement of the defendant. I think that it's 801, but I think even if it weren't 801, it would certainly fall under either 8036 or potentially 8038, but it's a statement of the defendant to the university for purposes of obtaining in-state tuition.
Okay.
As for 1255, Your Honor, this is the application for graduate school. As for the 401 and 403 objections, the court will remember that the defendant's attorneys examined, I think, two separate professors, but specifically Professor Sukumar, last name begins with a V, about him having reviewed specifically his entire application packet, and didn't he have stellar letters of recommendation. And so I think to say now that those actual letters of recommendation lack relevance or there's some unfair prejudice to them, I think is inconsistent with the position they took in the cross-examination of that witness. As for the 800 series objections, Judge, again, these are documents in part generated by the defendant, so they would be 801, and the other documents that came in after him were done at his request and become adopted admissions, in essence, of the defendant. He has adopted them by asking these people to submit these documents about him to this organization for the purposes of them deciding to admit him into the graduate school program for neuroscience.
Did he submit the letters of recommendation along with his application, or were the letters of recommendation submitted independent of the application by the professors?
Your Honor, I don't know the answer to that, and I can find that out from the witness who's going to be here later this morning. But for purposes of the argument, I would suggest that it's the same thing for purposes of him having this adopted admission. The inference being no professor is going to go out of their way to search out a grad school that someone's applying for unless they've been asked to do it and submit these particular letters of evaluation and recommendation. These are things that they relied upon. He wanted them to rely upon them when he made the application. And I think he even indicates further in the application the identities of the people who are going to be submitting letters, and they may appear as attachments. So I will ask about that, Your Honor. If that's critical to the court's analysis, I can find that out, and I apologize for not having that answer.
It's okay.
May I approach with one more document that I failed to give to the court and I'd spoken to Ms. Higgs about?
Yes.
This is Exhibit 1054. It's the defendant's transcript for his first year at the grad school.
Thank you. And Ms. Higgs, is there an objection to 1054 P-TR-1054?
Your Honor, we object at this point that it's cumulative. We object under 401, 402, 403, and 802. And Your Honor, with regard to the prosecution's argument that the letters of recommendation are somehow adoptive admissions, I think that flies in the face of what we all know commonsensically about how letters of recommendation work. There's no evidence that Mr. Holmes had them write particular things or wrote the letters and had them sign it, or in fact that he delivered them himself in any way to the university. In fact, one of the letters of recommendation, if you look at it, pages 41 and 42, seems to be kind of a digital fill in the blank, ask questions that was filled out directly by the professor. You know, the prosecution had the opportunity and could have brought in the professors that wrote these letters if they wanted the professors to be able to talk about what their thoughts were and recommendations were and evaluations were of Mr. Holmes. The prosecution didn't do that, and they're trying to backdoor this by saying that somehow the defense has opened up the door. I'm unclear where in the hearsay rule there is an exception that says open the door means that the prosecution doesn't have to comply with Mr. Holmes' constitutional rights and the rules of evidence. And if the court will recall, it was the prosecution who started on direct asking about the application process. They were the ones who first injected that into the testimony in this case. They cannot inject it and then claim that by crossing on it, we've somehow opened up the door to allowing them to get around the rules of evidence and Mr. Holmes' constitutional rights.
All right, thank you. Mr. Ruckler, are you intending, did you say that you are also intending to move these exhibits under the business records exception?
I think I can lay the foundation for that, Your Honor, but I also think that they would be adopted admissions under 801 for purposes of the documents in that application. And may I say one more thing, Your Honor, about that? The court will recall that in opening statement that Ms. Spengler made several references to the defendant's academic trajectory, and somehow the fact that he was tapering off or seeming to perform less well than he did before, which goes hand in glove with sort of the examination of Dr. Sukumar about the fact that he had these great letters of recommendation, he looked great on paper. There was a lot of conversation about that, and not just from the point of view of the people. Thank you.
All right, thank you. All right, can we bring the jury in now? Yes? All right, let's bring the jury in, please.
Before they come in, next present CTR-70, which is the disk from which the email P-PC-1227 were generated.
Yes. That was based on the discussion that we had yesterday at the bench.
That's correct.
Okay.
And I don't know if Ms. Higgs wanted to.
And that was a discussion on P-TR-1227.
That's right.
Good morning. Please be seated, everyone. Welcome back, members of the jury. How's everyone doing? Good. I hope you had a restful evening. Ms. Stitch McGuire, you may call your next witness, please.
Samantha Yowler.
And members of the jury, I should mention that Dr. Feinstein will return this afternoon for the rest of his testimony, okay? Good morning. Could I have you raise your right hand so that I can administer an oath? You solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Good. Could you please tell us your full name for the record and spell your first, middle, and last names?
Samantha Ann Yowler, SAMANTHA ANNYOWLER.
Ms. Teach McGuire, you may proceed.
Thank you. Good morning.
Morning.
Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and 20th of 2012?
Yes.
Who did you go to the movies with?
I went with my brother, Nicholas Yowler, and my boyfriend of 3 years, Matt McQuinn. We lived in Ohio and we moved out there in November.
Judge, I'm going to interject an objection at this point. 401, 402, 403.
Overruled.
You can tell the jury about how you know Mr. McQuinn.
Okay, we dated and we moved in November 2011 to live with my brother in Colorado.
How long did you date?
About 3 years.
How did you decide to go to the movie that day?
We talked about it for a few weeks. Me and my brother were going to go. Matt had to work the next morning at 4 a.m., so he wasn't going to go, but we had overlapping shifts at Target. We both worked there. And he told me that he decided he was just going to go.
An objection to hearsay.
Sustained.
Did Mr. McQuinn decide to join you at the movies after all?
Yes.
How did you get your tickets for the movie theater?
After I got off work, I went to buy him at the movie theater around 2 o'clock.
What time did you arrive at the movie theater that night?
We got there about 9:30 p.m.
What did you do when you got to the movie theater?
We picked out our seats, our favorite spots. I like to put my feet up on the bar because I'm kind of fidgety. And then to waste time, Matt just made jokes like always. We people watched, got concessions. It's like that.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 4704.
Yes.
Ms. Yowler, do you recognize that photograph?
Yes.
Who is that a photograph of?
Matthew McQuinn, my boyfriend.
Your Honor, at this time I'd move for the admission of People's Exhibit 4704.
Is there any objection, Ms. Spengler?
No objection to its brief admission or
All right.
publication.
It is admitted without objection, and I think she meant brief publication of it, so it may be published.
Thank you, Your Honor. May I please have 4704? Is this Matthew McQuinn?
Yes.
Thank you very much. Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1253.
Yes.
All right, if you could, that's just a diagram of a theater, is that correct?
Yes.
All right, if you could please mark on that diagram where it was that you and your brother, Nicholas Yowler, and Matthew McQuinn were seated that night. So if you could just put your initials on there, circle the seats, and then also please write your full name and today's date, which I think is June 18th.
Okay.
Would counsel approach for
Sure.
a moment, please?
Your Honor, at this time I'd move for the admission of People's Exhibit 1253.
And there's no objection, right?
That's correct.
Okay, without objection, it is admitted.
Your Honor, with the court's permission, I would ask Ms. Yowler to meet me at the 3D model.
Yes.
And if you could please grab that cordless microphone. All right, Ms. Yowler, if you could please show the jury where you were seated and where your brother, Nicholas Yowler, was seated and where Matthew McQuinn was seated.
Okay. I was sitting right here. To my right was Matt, and to my left was my brother, Nick.
All right, please tell the jury about what happened in the theater that night.
Okay. So I was watching the movie about 15 to 20 minutes, and I noticed someone came in from the exit door.
Could you please show the jury what exit door you're talking about on this model?
Here.
Okay.
And when I noticed the person came in, I saw a canister thrown over to the left side of the screen, and then there was smoke. And then after the smoke, I heard loud booms.
I'm going to stop you for a second. Were you able to see a figure that had come in through the door?
Yes.
Could you please describe for the jury what that figure looked like to you?
He was wearing a gas mask and dark clothing from head to toe.
Could you see if the figure had any weapons?
I could see he had a large gun.
Anything else you remember about the figure?
No, just he was up around this area.
Yeah, and if you could point just for the jury kind of as
Yeah.
much as you can. Or just,
Like around this area up here.
okay, thank you. What do you remember happening after that?
So after that, it was the loud booms, and I saw the orange like flames that comes at the end of the gun.
Could you show the jury where you saw those orange flames?
Yeah, still up around this area, up front. But it was directed more out though.
And when you say more out, do you mean more towards the upper left side of the theater or the lower left side
Yeah,
of
it
the
seemed
theater?
like it was
I'm
coming
going to
up more
object at this
this way.
point to speculation and lack of foundation.
Overruled?
You can tell the jury what you saw.
Okay. So it was just shooting. I could see the flames going this direction.
And just for the record, that she was pointing to the left direction of the
Left.
theater.
And
What do you, sorry.
Oh, sorry.
What are your comments after that?
It was just confusion. It smelled like fireworks, so I just kept saying, it's okay, it's just fireworks. It's just a promotional thing.
What do you recall after that?
So after I was convinced it was fireworks, we were just slouched in our chairs, not all the way down yet. And then Matt said, "Ow, that hurts." And then right after I was...
Sorry, I didn't hear what you said. If you could say it again.
Yeah, sorry. He said, "Ow, that hurts." And then right after...
No, I apologize again. Did you say that? Who said that?
I'm
Matt
gonna
said it.
object to calls for hearsay
Sustained.
and move to strike.
Right, what do you recall after that?
So right after that, I felt pain in my knee. And so I looked down and I saw blood. So at that point, we were on the ground. I was facing... My knees was facing to the right side of the theater, and I had my knees bent up, and then on my knees, Matt's head was around between my knees, angled down, and like his legs out. And so that's how we were at that time, and I had my sweatshirt against my knee to kind of stop the bleeding.
What do you recall after you guys had fallen in those positions?
After that, there was a lot more gunfire and confusion. And then I was trying to check on Matt, so I was shaking him and saying his name, saying Matt over and over. And then around that point, my brother's also holding me down just because we didn't know what was happening, where anyone was. And I was shaking Matt, and he had took a deep gasp.
Your Honor, 401, 402, 403.
Overruled?
A deep gasp, and then after a few times he kind of seized a little and stopped. Around that same time is when I noticed a green laser. I observed a green laser through the smoke, so I got quiet. And then at that point, after it got kind of quiet, it stopped for a second. People started running down this aisle, out that way, and I observed while they were running, the gunshot was closer to me, but he was shooting at the people that were actually
Objection
leaving the
calls for
theater.
speculation.
You can't speculate. You can only talk about you observe. Ms. Tishwai,
Okay.
why don't you ask a question?
Sure. Could you observe the shooter and the direction that the shooter was shooting in?
Yes.
Same objection, lack of foundation.
Overruled?
Please describe for the jury exactly what you saw the shooter doing.
So I saw the green laser over by me, and I saw the people running out of the theater, and the gunshots were to that direction of the people running out.
So earlier you had described that there were people on this left side of the
Yes.
theater, and that's where the people were, and you saw the gunshots in this direction towards the people that were fleeing.
Yes.
Okay, could you see the green laser over here at this point?
At that point, it was still like just over me. I could see it in front of me.
And then after you saw it in front of you, you saw the gunshots in this direction.
Mhm.
Okay. What do you recall happening after that?
So after that, the movie was still playing, but the gunfire stopped. So we were just waiting. I couldn't go anywhere because of my knee, so we were just waiting for help to come. And in that same front exit door, I saw another gun come through, so I was kind of afraid, but then it turned out to just be cops, and then a ton of cops were in there. And then at that time they turned the lights on. So when the lights were on, I observed there was a person sitting below me that was shot in his head.
Objection, Your Honor. 403. And cumulative.
Could you observe your injuries at the time?
Yes, I know my knee was bleeding, and it felt like a lot of pressure.
And what knee was it?
On my right knee.
Right. What else could you observe next to you?
Next to me. So Matt was still on me, and his glasses were crooked, his eyes were closed, and I saw some bubbled skin on his neck and injury.
And what part of his neck?
His right side. But at that point, I was just hoping he was unconscious.
What do you remember happening next?
So then the police officers asked me if I could walk, and I told them I couldn't. So my brother and some other police officers carried me over the bar.
If you could show the jury what you're talking about.
They carried me over this bar and out the exit instead of over Matt. So they carried me out took me out the exit door, and they laid me on the sidewalk outside the theater. At that point, I was triaged and waiting for...
Judge, I'm going to interject an objection at this point at 403.
Overruled.
All right, Ms. Yaller, you can go ahead and finish answering that question. So.
Okay. So just waiting for the ambulance or someone to come get me.
All right, and I don't have any further questions for you at the model. You can go back and take your seat on the witness stand. Were you eventually transported for medical treatment?
Yes.
All right, and I'm going to ask you to pull that microphone a little bit closer. When I asked you to get it, probably got farther back. Where were you taken?
Denver Health.
How were you transported?
An ambulance.
Were there any other people in your ambulance?
Initially it was just me, and then they moved me over, and there was another victim who lost a finger they shared with me.
What hospital were you taken to?
Denver Health.
Please tell the jury about what injuries you sustained as a result of the shooting.
So my right patella, which is my kneecap, was fractured in multiple pieces.
All right. Your Honor, if I may approach the witness with what's been marked as People's Exhibits 4661, 4664, and 4665.
Yes.
Your Honor, may we approach?
Yes. right, the objection is overruled, and all three are admitted. That's P-DR-4661, 4664, and 4665. And they all may be published.
Thank you. Could I please have 4661? Ms. Yowler, is this a picture of you in the hospital after July 20th of 2012?
Yes.
Could I please have 4664? Please describe for the jury what we see in this photograph.
So that is the exit wound, the big missing piece. That's the exit wound, and then there's some flash burn above that. And then on the very top, there's the entrance wound, but you can't really see it very well.
There's a mouse in front of you that does not work very well, but if you could do your best to show them where closest to where you're entering.
Below that, it's not going to, but
okay.
Just a little below that. Right there.
All right, and this again, which knee is this again?
My right knee.
Okay, thank you. If I could please have 4665. All right, please describe for the jury what we see here.
So this is where, after my first surgery, they just cleaned it up and they sewed it back up. So the entrance wound at the top there has some stitches, and then they stitch up the side. And there's a little bit of burn above there.
Could you please try to use that pointer if it'll work and show the jury where the entrance room is?
Okay, so a little above there is the entrance wound.
And then where were the other injuries you were describing, the burns?
The burns are the pinkish area right there.
All right, thank you very much. Ms. Yowler, at some point did you find out that Matthew McQuinn did not survive the theater shooting?
Yes, right after my surgery later that night on July 20th.
Thank you very much. I have no further questions for this witness.
Is there any cross-examination?
No.
All right, and the jury does not have any questions for this witness. May this witness be released from her subpoena?
Please, thank you, Your Honor.
Any objection?
No objection.
All right, thank you. Call your next witness, please.
At this point, I'd like to publish people's exhibit, PDF here, that's 1227.
All right, and you have copies for all the jurors? If you would hand those to my staff, please.
And Your Honor, we'd also ask to publish DTR 65, which accompanies that same exhibit.
Yes, that request is granted as well. So Ms. Robinson and Ms. Gerling. Ms. Robinson and Ms. Gerling, if you would, please.
There's 19 copies.
All right, members of the jury, one of you needs a break, so let's have you give those back, please. We'll take our morning break right now, and then we'll proceed with your review of the exhibits that were just distributed in just a moment. So let's take 15 minutes, okay? Please remember all my advisements apply during the break. Thank you. Please be seated, everyone. The record should reflect the jury has exited the courtroom. Is there anything we need to talk about before we take our break, Mr. Edson?
Judge, I just need to place on the record, I gave the defense 2 interview statements from our investigator. One was for Joe Jose Lopez. He's a witness from Gander Mountain. My investigator met with him yesterday, generated a report, and I immediately turned it over to the defense. They actually received a copy yesterday, and I gave them the same copy again this morning. And overnight, one of our investigators had a clarifying confirmation question for David Bunch. He's the 24-hour fitness witness. And that report I immediately gave to the defense as well. I just want to put that on the record.
All right. Anything from the defense?
Want to hear argument on the hot mails.
Can I wait till the lunch break?
I hope so.
All right. We'll do it during the lunch break. Thank you. The court will be in recess.
Please rise.